Good morning. To understand the Constitution and certain words, this judgment would help you because the multi number of constitutional judgments were discussed, and particularly Article 13, Part 1, Part 2 are discussed about the validity of the post-constitutional laws and pre-constitutional law. This is case AR 2023 Supreme Court 4854. AR 2023 Supreme Court 4854. CBI versus RR Kishore. Actually, what had happened, this appeal was preferred against allowing application to remand back to the authority to apply Section 6A of the Delhi Special Police Establishment, which was amended 2014. See, actually, the 6A says that the employees of the central government of the level joint secretary and above, such officer as are appointed by central government in corporation established by under any central government employees, society, local authorities. Therefore, they say they want if you want to prosecute these officials, these specialized listed officials, so there should be approval of the central government by inquiry. So that was challenged by Dr. Subramania Swamy, and that was allowed in the year AR 2014 SC 2140. They have declared that this amendment Section 6A of the Act is invalid in Article 14 because it is not reasonable classification. There was no equality before law or equal protection before the law. So therefore that was allowed. Here what had happened, whether that declaration of 6A's invalidity declaring void has got retrospective or prospective. So they say since Section 6K is not punitive because it was not introduced for any new offense or enhance the punishment, it should be procedural. Therefore, this judgment says that the judgment declared in the year 2014 Supreme Court filed by Dr. Subramanian is retrospective, not prospective. Then they say what is the difference between validity, void or void means that not legally valid or binding when used as an adjective, and further when used as a verb it means to declare that something is not valid or legally binding. Then question of doctrine of eclipse. Doctrine of eclipse, see Article 13.1 says the pre-constitutional laws are if it infringes, any provision infringes the fundamental rights guaranteed under Part 3 of the Constitution, that the area of act is illegal. If suppose certain shadow may be there in that act, just like instead of Tamil Nadu, instead of Karnataka or Kerala title in the act, if there was only the state of Trivangor, so many things are there. If that shadow is removed, the act became valid. If suppose some words are used discriminating between the men, if that particular area is removed, then the entire other provisions of the act may be valid. That is called doctrine of eclipse. You know about the eclipse. It's a shadow of either moon or earth over sun or moon for time being, and thereafter it will shine. Like that, if you remove that eclipse, then they say so far post-constitutional laws are concerned. Post-constitutional law, before constitution, is doctrine of Ecplice is not applicable. That was they say. That was discussed deeply at every page. Therefore, multi-number of judgments were ex post facto laws, removal of provisions. That ex post facto laws means the laws is being introduced after committing the offence is not valid. So that area will. So if you want to understand the Constitution very deeply, go through the judgment paragraph by paragraph or title by title by referring this index. If you are interested to know what is void or what is adjective void or what is verb void means, or if you want to understand doctrine of Ecplice and you read para 42, like that you read area by area. So many judgments were discussed. Here you know what is why the CBI is there. Delhi Special Police Establishment was initially established for the purpose of Delhi only, and slowly that act has been empowered CBI authorities to investigate. Therefore, the Special Police Establishment Act is code for CBI. So this case is there. Somebody seems to have, after getting bribe for prenatal test to determine the sex, when he was charge treated, then they raised an objection that 61A was not followed because he is holding rank of joint secretary. This they say that was not allowed. High Court allowed it and remanded back for inquiry, re-inquiry. That was challenged by the Supreme Court. So this was challenged in the year 2007, and this case was disposed 11/9/2023. Okay, namaskar.